You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everyone. This is Ashton Kirsch, your host with the Subrogation Support Network, for a wonderful podcast today on mediations, mediation practices, the post-COVID era of mediation, and what you as an adjuster or an attorney can do to maximize your recoveries through mediated settlement agreements. It's my honor to host this show and to have as our guest a good friend of mine, Jason Rosen, with Rosen Resolution, joining us today. Jason is a mediator operating out of Seattle, Washington. Jason, thanks for joining me today. How are you doing?
Ashton, I'm doing well. Thank you. Thank you for having me. I really appreciate the opportunity to come on and talk with you and your audience.
So Seattle's a great place, by the way. I've spent quite a bit of time out there. I actually had a layover where my flight was canceled, and I spent a night there last year and had just a blast. I mean, a beautiful city.
It is fantastic, especially during the summer months. I encourage everyone to come out, and if they do, feel free to reach out, and I hope you get back here soon, Ashton.
Of course. Now, Jason, tell me a little bit about yourself and your mediation practice.
Sure. So I was raised in Seattle. My professional career has been entirely in Seattle. I was born on the East Coast, back in New York. We moved around a bit before we landed here, but I really, grew up in Seattle. So I've got a little bit of that sort of East Coast vibe that I think I've kept with me, but also, the laid back Seattle attitude that I think, is definitely noticeable. I was on a meeting earlier today talking with some other ADR folks about the difference between sort of East Coast and West Coast mentalities. So hopefully I bring the best of both worlds. But
beautiful. Beautiful. So you don't always wear a tie. Is that what you're saying?
I do not always wear a tie, although for mediations, I always do. Even for Zoom mediations, I put the full suit and tie on, pants included.
Well, pants are important, but I always have a hard time with the tie. But sorry, I'll digress. Let's go back into you and your mediation practice. So tell me about Rosen Resolution and what you guys are doing.
Sure. So Rosen Resolution, I started about 7 years ago. I had gotten a certificate in ADR, Alternative Dispute Resolution, in law school, and always, I think, practiced with a bit of a pragmatic mindset. And somewhere in the back of my mind, I think, felt that I would maybe be better suited as a mediator than a advocate on one side or the other. I enjoyed doing that and made some great relationships. But when I felt that it was, an appropriate time to branch out, I did that. My practice was primarily in insurance defense on the casualty side, mostly personal injury, some public entity, a lot of public entity liability, cities, counties, the state, and sort of construction site injuries was, another focus.
So what is the geographical territory that you cover? Who are you, what carriers, what geographical areas are you primarily mediating cases in or for?
Yeah, great question. Primarily in the Northwest, Seattle and the broader Washington area. I've done a bit in Canada and California. Certainly open to branching out with Zoom. I can work anywhere. So, happy to expand that region.
That's kind of a fascinating place we're in today, where prior to COVID, almost the vast majority of mediations that I'd attend, and that's, dozens every year, they were in person. I was flying out to Seattle, flying out to Los Angeles, right? Driving up north to Manitowoc, Wisconsin, wherever it is, to sit down in an office, have some stale coffee and maybe some bagels, and mediate in person. And I definitely think there's some benefits. There's some pros and cons. But how about on your end? Are most of your mediations now virtual, or are you doing anything in person? How does that work with Rosen Resolution?
Like you said, before the pandemic, people were very resistant to mediating online, and almost literally all of my mediations were in person. I think there was one where we used Zoom, which I hadn't even heard of until then, to have the plaintiff who was in Arizona participate. But other than that, it was unheard of. Obviously, we went 180 degrees and figured out that we could mediate by Zoom during the pandemic, and we did so. Right. And that was the big question. What was it going to be like once we had the opportunity to go back to in person? And I've found that in my practice, the default is Zoom, but I've done several in person. They kind of go back and forth, but I'd say it's been 50-50 recently. And, I suspect that will continue to sort of be the trend.
Getting into kind of one of the main topics I really wanted to talk about, and that is getting into kind of the meat of the pros and the cons of virtual mediations. I can say that, on my end, obviously, what are the pros? The pros are I can sit here right where I am right now, attend a mediation anywhere in the country. And what that does is that, makes mediation more feasible, right? Even on smaller cases or on cases where we can do it earlier, even sometimes have multiple mediations where we will have a pre-suit mediation, which I want to discuss in a few minutes. But there's those added benefits, right? It's the idea that it makes it simpler, it makes it more efficient, more effective. I guess the cons in my mind, before I ask you about it, I think the difficulty is trying to, the question always is the adverse party is ever going to come with true full authority? Are they going to have the same incentives to resolve this when it is so easy, right? When you have to go fly out somewhere, sit at a table across from the other side, and then go back and fly home realizing that you didn't come to a resolution, it hurts a little bit more, right? It's also more costly to not come to a mediated agreement. I think those are some fascinating, things to talk about. I mean, what do you think? What are the pros and cons that you come up with on this?
Yeah, I mean, I think you absolutely nailed many of them. Clearly, efficiency is an upside. You can break the mediations up into, shorter segments because people don't have to travel to convene. You can have a meeting with, say, plaintiff and plaintiff attorney in advance of the actual mediation day to sort of get that, that conversation that I think is important to developing rapport with the plaintiff, but is perhaps an hour where the defendants who are simply looking at the clock are sitting in the other room going, why are we wasting our time? What are they doing over there? Let's just get down to numbers, right? So you can break those up and work asynchronously, as they call it, so that somebody isn't sitting in the other room while you're having a conversation with the other party. Cost savings and right, location doesn't matter, as you said. So you can work with multiple parties, in multiple locations, and you get more participation, I think, from adjusters. You probably heard that people who, otherwise would have been on the phone potentially, so they didn't have to pay to travel to a remote location, can now participate easier. And rapport works. We've found you can still build rapport through Zoom. On the flip side of that, right, there are some negatives. And with respect to rapport, yeah, you can do it, but you don't get the eye contact. You don't get to see body language in the same way. So those are some of the downsides, right? Other downsides, Zoom fatigue. That is real. You definitely, I think, more wiped out after spending all day looking at the screen than you are in person. Right? Technology can be an issue. If you don't have a robust connection, that can really impact a mediation negatively. And you may need to buy special expensive equipment for online that you don't need in person. And you don't get a free lunch and snacks from the mediation firm when you're doing it in person. So I know that's a downside for some.
Right. And, I've had a few clients who have come to me recently and even asked and requested, hey, you know what? We want to do this mediation in person. Primarily my trucking clients, right? Where it's large self-insureds and they're not necessarily dealing with the same thing on the liability end because they may be insured there. So they want to actually be in person. And I can just think of some of the responses I've had at this point in time from adverse adjusters. Basically, absolutely not. Like, no, we're not doing it. Or, opposing counsel just being utterly just flabbergasted or confused by the request. It's why would we do this in person? It's so easy to just have it virtual. So there's definitely pushback there. And just industry wide, you see more and more carriers, agreeing or mandating that all mediations be done via Zoom. And, most carriers, I mean, they're saving quite a bit of money. They're paying, at least on the defense side, they're paying their attorneys less money to not have to go drive out or fly out or sit there all day, right? So it's kind of a way that, I don't think it's a change. There's some post-COVID changes that are turning around, right? More people are going back to the office. Court hearings are starting to be in person again. But I do think that this change for mediation, I think it's going to remain. I think that it's going to be, while there will still always be in-person mediations, I think that there's going to be a huge part of this, that it becomes and remains very standard practice to have mediation attendance virtually. Would you agree with that, Jason?
Yeah, absolutely. I think you're right. I think it's going to be the default. And then if there's a particular reason why one side or both sides wants the mediation in person, then that can be a topic for discussion. And there certainly are instances where in person is perhaps not just beneficial, but necessary, but it's sort of case by case. So I don't know that, it would be efficient to sort of go through all of those or any of those.
Yeah, and an example would be that I had a case a few months ago where it was we had a claimant, large work comp subrogation. We were jointly prosecuting and also working with the claimant. And the claimant, really had some, I don't want to say unreasonable, because I mean, it wasn't necessarily unreasonable, but, had very high settlement expectations and a lot higher than I probably had thought that they should have been. And the defense they were even worse, right? Their exposure here was significant, but in their mind, in the adjuster's mind, who frankly, I'll be honest, had no idea what they were talking about, they thought that their case was worth nothing. So, I mean, it was one of those ones where there was some money on the table. We decided to mediate, and it was one of those situations where I decided with client consultation that this would be the right case to have everyone get together so there'd be more of that form of communication. Though not necessary, there's still situations where in-person is still, in my mind, recommended. Now, one thing I want to touch on is just certain problems with professionalism that I've seen with virtual mediations and things that I would love to get your insight on. Right? We see Jason, have you seen the cat lawyer videos with the guy who accidentally had the cat filter on his face?
I have.
So, I mean, for those of you who haven't seen it, research cat lawyer. It's basically a lawyer who's attending, I don't know if it was a mediation settlement conference, whatever it was, a court hearing of some sort. And he accidentally had one of the cat filters where your face becomes basically a cat, and he couldn't figure it out. It's hilarious to see, but it's kind of just shows me when you have people that have been practicing for years, maybe are still dictating, but now they're expected to use technology to be really the form of communication. I mean, it gets interesting. And that's where for the last couple of years, you go to any conference, this has been a major topic, and it's been it's relatively redundant. It's been pounded into most attorneys and adjusters' heads, how to work. Now people know what they're doing. But at first it was hilarious just to see the issues we'd have. And there's a lot of forgiveness. But now it's kind of an expectation in the practice that we know how to use technology. We know how to meet virtually. But I still think it's important to stress, and I inform all my clients before we go to a mediation or anything where clients going to be coming forward virtually, so we have to remember that we treat it in the same way as if we were appearing in person, right? We dress appropriately. We wear pants, right? Who would have thought that would have been something we need to remind our clients of? But we wear pants, right? We wear that tie if necessary, if it's a court hearing. We approach things correct because there's a lot more room for people to be more and more, be it relaxed, in their own element when they're home or when they're in their office, which is a benefit. Because the more relaxed you are, frankly, the better, in my mind, you're usually going to negotiate. But also there's negatives there. I think of the story of last year I had a case, and I can't give too many details because, there's certain things I can't go into, but settlement conference in a state where we have a duty, and it's basically a full mediation done by the court. We call in all virtual. There's a claimant, there's claimant's attorney, there's us. We have a PD claim. There's a work comp subrogation claim, all the above, about a dozen attorneys virtually in this meeting. The claimant wants to appear as well. He's there too. And he happens to be calling from a car. All of a sudden, we have this guy jump on, wearing a tie-dye shirt, flap-rimmed hat, like really, sideways. But he's a middle-aged man, but he's in a very interesting attire, right? For what is a professional setting, not what he would wear if he went to court. Well, next thing you know, we realize he's in his car and we look over, things are ongoing, and we notice he starts smoking a few cigarettes. And I'm waiting for the judge to jump in and say something. Well, nobody says anything, whatever. It's more relaxed. It's not the attorney, it's the claimant. Fine. We'll give him some leeway. Next thing you know, he gets out of the car, comes back in, cracks open a beer. He's drinking a Busch Light in the settlement conference. All right. Obviously, you're not doing that in person, but, still waiting on the judge. A few minutes later, well, maybe like an hour later, he gets out of the car and you could hear him. He didn't know how to use mute. And he starts actually talking to these ladies and saying, hey, come back and hang out with me in my car. I'm on this hearing. At which point the judge had to jump in and start talking. And more of the story is at the end. I love this one because he's at a concert and this guy sells concert merchandise. And what he ends up doing is he ends up, showing everyone there, in exchange for forgiveness, the judge had asked that he show the concert that he was watching. And we got to, very briefly watch at least half of a song for a very famous band that was right there on the stage during the conference. Okay. That's a long story to get to what? Well, what I'm getting at here is, everyone has good stories about this, but ultimately we just need to remember, like, that's not professionalism. Still a great story, but these things are happening left and right. And I advise all my adjusters, all my clients to make sure that anyone who we have attending on our behalf in a mediation, whether they're virtual, just to make sure that somebody's informing them how to operate. Because obviously that guy in my story was never informed of that. Any thoughts on that or any interesting stories you've got over there, Jason?
Yeah. You're exactly right. You get all sorts, and typically people treat these, with the reverence that you would anticipate, but not always. I want to create a environment online that is as close to in person as possible. I have breakout rooms and go back and forth just as I would with conference rooms in person. I took a course when COVID happened on doing online mediation. I think, yes, we are all familiar with it now. And frankly, I don't do as much to ensure that perhaps, plaintiffs who may be less sophisticated are, going to be dressed appropriately and have the right technology, et cetera. But for the most part, that hasn't been an issue. But there have been instances where plaintiff is sitting in their car during a mediation. I've also had instances where some counsel are less prepared than you would hope, not to the point of a cat filter, but I've had attorneys who have been mediating on their, kids' computers, and they don't change the name. And so, you see the daughter's name through the entire mediation, things like that. But
and who would have thought you'd see so many dogs in mediation, right?
Oh, the dogs, the kids, the significant others walking around in the background. Absolutely.
Oh, that's good. It reminds me of, so I had a case, it's probably last summer, where everyone knew. I informed all the parties that if they wanted to keep that date, I would have to be attending from the car because I was traveling back from a deposition, and they all wanted to go forward with it. So perfect. I informed them that, hey, I should have perfect reception, but if there's any issues, this is why. And of course, that morning, driving up to the deposition, and my air conditioning goes out in my car. So next thing you know, I am attending this mediation from my car because this was way up north Wisconsin where there's really no, conference rooms or libraries or anywhere else I could have set up. And next thing you know, everyone's watching and it's about 105 degrees outside and just sweat. And I'm soaking wet at the end of this. And everyone's laughing because they know, I've provided the context, but it's, I'm pretty sure any attorney or judge that handles a lot of these mediations has to have at least a corral of 20 good stories about, snafus that have occurred handling things remotely.
Sure, right. You also get the cat that walks right in front of the screen and across the keyboard. So there's all sorts of, snafus, as you say.
Right. So now I'm going to toss you a nice softball question here, Jason. Why is mediation important, just generally speaking?
I'm glad you consider that a softball. I don't, I think there are a handful of reasons. I think it allows the parties to sort of lower the temperature in the negotiations. If you put a neutral in the middle who really is disinterested in the outcome, obviously as mediators, we want to see an outcome, a settlement, but whether or not, we have nothing invested in what one side gets versus what the other side gets. We just want them to find a solution. And so it really allows for, I think, some different perspectives to come in and, discussions to be had in a way that may save face. People can change their positions. I think a little easier if there is a neutral and you're using this process of mediation where either things can be discussed that won't impact the litigation or won't come into the litigation if the matter can't resolve. Right? It just it's my long-winded way of saying there are many ways why it's important, but one thing I wanted to mention was I think it's also important in the skills that mediators employ, as far as the way we hopefully direct the parties to approach their disputes, their situations, in terms of looking at it from the other side's point of view and sort of asking questions and helping them see the bigger picture. And I think those skills should be taught more broadly, because they really sort of translate to everything. And so I think the concepts of mediation are important as much as the process.
Right, because it's creating a forum and an opportunity for these parties to really, frankly, no holds barred, go towards and work and fight for an agreement if there's one that's possible. But your role as a mediator is to, one, provide that forum, but also provide that neutral third party's perspective to sometimes, bat down arguments to the other side, explain, here are the issues with your case, here's what you have, and really be the, be that referee, and not in a way be that referee, but also, when it comes to the negotiation, also be that quarterback, right? Have the role of actually coordinating things and helping the parties fit into the right places, understand each other's cases in a way that could lead to a resolution. I've always been a huge proponent of mediation. I resolve probably at least the vast majority of my cases that I take to mediation, I'm usually resolving through selecting the right mediators and approaching it and setting up my case to be mediated. I've recently even been starting to push for early mediation and sometimes even pre-suit mediation. My thought is most jurisdictions have court-ordered mediation, whether it occurs early in the case or late in the case. And many other jurisdictions will even honor pre-suit mediation, right, to hit that mandatory requirement. So a lot of times we're trying to take those steps, and I'm trying to advise my clients, you know what, maybe before we get through all of the depositions, maybe just after some paper discovery or whatever, even pre-suit, if it's a case that we don't necessarily need significant discovery. I'm trying to push to get these mediations on the table as soon as possible because resolution early benefits everybody, right? I come from the subrogation side, so I am the plaintiff's attorney. My clients are primarily paying me a contingency fee, right? But there are significant costs. My coming to my client saying, hey, we can resolve this case today for 85%, or try it and probably get you 85% with a big question mark in 2 years when this goes to trial. What do you want? Well, their answer is going to be get the money today, right? Even if it's on a contingency fee. Similarly speaking, on the defense side, obviously, the sooner that gets resolved, the sooner they can avoid paying those defense costs, those defense fees. So ultimately, I think that there's a huge benefit to encouraging mediations, as I do to all of my clients, and also encouraging them as early as practical. What are your thoughts there on the necessary earliness of mediation or when the right time to mediate is?
Yeah, you are right on target, Ashton. Going back to the importance of mediation, you're right. It is extremely effective. It works approximately 80% of the time. 80% of cases that mediate will resolve as a result of that mediation. And as far as early mediation, it is not used nearly enough. There have been studies done in the insurance world, litigation management world, where insurance executives, 85% of insurance executives and like 60% of defense attorneys say that most claims settle too late in the process. And at the same time, those later settlements aren't decreasing the indemnity that is paid on the case. So I think there is absolutely a need for early and even pre-suit mediation. And even if that early mediation doesn't resolve the case for whatever reason, parties aren't ready, need more information, et cetera, it often helps streamline the process and set a much more efficient path to the ultimate resolution.
Right. And with virtual mediations, it makes it so much more feasible because there's a cost, but it's not as much of a headache, right? Where we can schedule it early. And it's okay if the adjuster will attend. Okay, they'll pay, $1,000, $2,000, $3,000 on a large case. Frankly, that's nothing cost exposure wise when we may be able to get this done for what the client wants early, right? A lot of attorneys and a lot of adjusters think attorneys, they need to be pushing all this paper on every case and, going through the motions. The fact is, yes, we need to be excellent litigators. We need to be prepared to take these cases to trial, every single one of them. But that doesn't mean that every case needs to go through the entire process. And the sooner we can get these cases, start that conversation, the better. And a lot of these cases, it's really hard. Both sides are really having a hard time. And my clients all the time, when I try to negotiate, I'm always going to ask first, right? I'm not going to reduce and unilaterally make a reduction. And the other side has a hard time, like, yeah, you sent me this demand. This is ridiculous. I'm not going to make the first move either. And you're stuck in limbo, in this negotiations purgatory where, what happens next? And that mediation, that alternative dispute resolution mechanism, it gives us that opportunity to, without necessarily laying out our cards immediately or being the one to make that first significant move, it gives us that ability to open that forum. And then we know, right? If it's early in litigation, we go to mediation and the adverse parties or one of the two parties tells the other to pound sand and there's just no, it's not even close to a resolution. Well, then we know earlier on, oh, wow, this is a case where maybe we are justified telling the client now, spend the extra money on experts, right? Let's get that more significant review. Let's get that product out to the materials engineer so we can have them look at things that maybe in other cases, we have to approach this assuming maybe there'll be a negotiated agreement. But if we know early on that it's looking like this is not going to settle, then that gives us a better ability to plan our negotiation, our litigation strategy. So there's just a ton of benefits here that go far beyond just the simple idea of just mediating a case because you have to.
Right, exactly. I mean, if the early mediation doesn't settle the case, like you say, use it to target the areas that need more discovery, more information. Um, Focus on those, and then come back to the negotiating table. You can often, find enough information in, the first 20% of, an anticipated case's lifetime, to evaluate it enough to reach a settlement, right? It's sort of that 80-20 principle. And the likelihood that spending the effort and money and time that it will take to gain that additional 20% of information usually vastly outweighs any benefit. Cases tend to not get better. And so, I think there's a lot of missed opportunities and a lot of, waste, frankly, in the infrequency, and I think lack of using early mediation.
Because you never know where the other side's going to go until you know. I can't tell you how many cases I've had just this year alone that we went to mediation on, and next thing you know, the adverse is way above anything we expected, right? We are immediately in our reasonable zone of settlement pretty quickly after entering the mediation, right? So then we're just negotiating for the cherries on top. But there's also just that perspective that when we're going into these things, both sides have their reason to kind of keep their cards hidden until a certain point. And having that neutral third party, people like you, Jason, the mediator, to kind of go in there and just give us that context and idea of, are we really too far apart or are we right there? Because defense attorneys are going to have a really hard time, telling their client, oh yeah, some liability, and you did defense work. It's hard to go to your client and say, hey, you have this giant exposure. Let's get it done. And for all they know, plaintiffs on the same side saying, hey, I just want to get something here, right? Alternatively, could have these subrogation cases where the adverse thinks they have this huge exposure and we're reasonable. So there's just so many places where by facilitating the dialogue, and I do this pre-suit with a lot of negotiations in general, right? We're having these discussions. We're not locking ourselves into positions early. We're making sure that we set every case up to be as economically viable for the client as possible, because the last thing we want to do is charge them a ton of attorney's fees for something that we can get done through early negotiations / mediation.
Right. Well, you and I have presented and spoken on negotiating and how to optimize claim outcomes. And I think one thing that we as humans tend to do is make assumptions and not ask enough questions early on. And right, so we get stuck in the mindset that this case is just going to be difficult and adverse, and we're going to have to work through the steps. And if you don't, reach out to the other side, ask some targeted questions, build rapport a little bit to the point where you feel you're going to get valid answers. Then you do wind up going down a road that may be much longer than it needs to be.
Yeah, I should have mentioned that earlier to the audience. Jason and maybe was it 2 years ago, sometime recently, we did a presentation on negotiations and kind of in mediations, best practices, tips, tricks for CLM, which is an organization we were both very active in. I have the opportunity to run into Jason usually several times a year at those events.
Yeah.
Next question. Now, I wanted to talk about the idea of selecting a mediator. Obviously, you're going to be slightly biased, and I am as well for you because I think that your company is excellent and you are a great attorney and mediator. But what kind of advice should you be giving, or should we be giving our clients, and should attorneys be taking in best practices in selecting the mediator? Obviously, we're looking at, certain factors such as, your background, right? Do you have a background in a specific subject matter? Your geography, past experiences. What else do you have to add to that people should be considering?
Yeah, I think those are important. I would encourage people, one, to be open to using new and diverse folks. I will say that not every mediator is right for every case. I mean, there are cases that, I think I would feel uncomfortable mediating, and some that are right in my wheelhouse. So, how do you find that out? I would say reach out and have a conversation with potential mediators who, either have been proposed or you just know of. Interview them, see if they're going to be a good fit. Both if you think they're going to be a good fit and if they think they're going to be a good fit. They would appreciate the opportunity. And, I think there are any number of factors that might dictate, how you select. Like you say, do you want somebody with subject matter expertise, or do you want somebody that's going to be able to, address the various personalities that you anticipate being involved, or both? But there's oftentimes one particular factors that are more important to a particular situation.
Yeah, in my experience, I think every attorney, every claims person is going to be slightly different. But my approach is always, the most important thing to me is like step one is just subject matter. Do you have the ability to understand the subject matter as the mediator, right? If this is some super complex construction defect issue, which requires, 15 hours just to study up on how, facades work and the structural issues and so forth, and you've never handled a construction case before, well, maybe that's not the one. But if it's something that mediator has a general understanding of the subject matter at hand and can review and understand these things, which is typically the case, then my next step is always just practically speaking, who has that communication skill? Who has that personality to really work with the parties and get things done? Because, just because somebody spent years as a judge doesn't necessarily mean that they're going to be an amazing mediator, right? And just because somebody was, a litigator for years. I mean, it's really the specific person, because I've probably been in front of 400 different mediators in my practice. And everyone has their different quirks, their different things. But there's different approaches, different strategies, different communication styles that work and don't work for different cases. And frankly, it can be for different parties in different cases, right? Some mediators I know are perfect for those cases where both sides are really hard in their perspectives. Maybe the attorneys are relatively in agreement that the case should be resolved, but both clients, both insureds are just adamant, or whatever it could be. It's just the right person for the right job is hugely important. Another thing that's kind of, you see is pretty standard amongst a lot of attorneys, and what they'll do is, if they're on the plaintiff side, they're going to want the plaintiff's mediator. If they're on the defense side, well, they want that person with defense experience. And, I don't find that a useful tool at all. In fact, I usually personally take the exact opposite approach. Obviously, most of my practice is subrogation. It's plaintiff side. So you'd think that one of those, old plaintiff's attorney mediators or a judge who's plaintiff friendly would be the right person. But, my approach is usually I'm trying to find that mediator who that adverse insurance carrier, that adjuster is going to think that they're on their side, right? Because, assuming that they're not, and there's no bias there, I like to be sure that I have somebody that is going to be able to go into that room, especially on maybe a tougher case, and talk to the defendant and make clear, like, sure, I did this for years. I did liability, I did defense work for the last, 30 years. And I looked at this case and you have exposure, right? It creates a commonality. It creates kind of an understanding between them. So that's really my approach. And everyone has different approaches. But, any other advice or guidance from you, Jason, on what people should be looking at or what questions they should be asking people like yourself before agreeing to mediate with you?
Well, you're right. You want somebody that you're going to enjoy working with and that you're going to trust. But more importantly, you want somebody that you think the other side is going to enjoy working with and is going to trust. So oftentimes you're right. It can come down to personality. Subject matter, again, can be important, but the mechanics of these things, whether they be mediation or arbitration, are fairly routine. personality can be a big part of it. And so, again, going back, I would say reach out and talk to that person before you elect to agree to them.
So now, obviously, all mediators are different. The strategies used, and there's obviously common ones, right? Let's do brackets, let's do this or that. There's always a question of whether or not we're going to have a groups meeting at the beginning, if we're going to present our sides. I have a mediation this week where we're legitimately both sides are presenting a full PowerPoint presentation to the group, to the other side. And other situations where the majority of mediations now, the parties never see each other. And I have some mediators who dictate approaches, others who will call us up and ask, hey, what do you all want to do? What creative mediation strategies do you utilize that you think can help parties get to an agreement?
Yeah, great question, Ashton. I think on the West Coast, we default towards no joint session. And that's typically how things go. Now, I think there are times when a joint session can be very helpful. And so that is one tool that I think is creative in this jurisdiction, in the sense that, it's not used particularly often, and you can't force it. But if at any time it looks like that's going to be something that might move the ball, it's definitely worth exploring with the parties. One tool that I've used recently and I think is extremely helpful is decision tree analysis, and sort of talking with the parties to figure out sort of what they think might be a high, a middle, and a low outcome, and at what percentage they think each of those might occur. And you can get a much more objective evaluation of the claim and of sort of the anticipated value, as opposed to people using terms like, oh, well, I think we've got a pretty good chance of getting X amount. Well, what does that mean? I mean, that can be 80% to somebody and 20% to somebody else. And so if you can break those down into more quantitative figures, that can be extremely effective. You mentioned bracketing. I think bracketing can also be a highly effective tool to move the process along and provide some additional information to the parties without them having to commit to a particular position.
Attorneys also take very differing approaches and different approaches to pre-mediation statements, and be it the memorandum basically sent to the mediator. What have you seen that you think works best? My approach has always been, I want the mediator to know it all, right? I want you to come in there, and when you have your perspective, I want you to really be, know everything about my case and know my arguments and my side of the case. Is it helpful for you to have a more substantive, like detailed pre-mediation statement, or what's kind of the common basis there?
I like as much information as the parties are willing to share before the mediation, and as far in advance as possible. One of my calling cards is the amount of preparation that I put in before a mediation. I may spend as much, if not more, time getting ready for a mediation as we have scheduled for the actual session. And so I'll look at anything the parties are willing to share. And I do think that more information is better and helpful. I highly encourage parties to share their mediation briefs with each other and get those cards out on the table, as you say. I think, mediation really should be an opportunity for the parties to look at things a little differently, look at things from the other side's perspective, and sort of figure out where the other side is coming from, as opposed to, pounding the table and standing behind their position, because that's just going to increase the likelihood that the matter continue down the path towards settlement. I mean, you can be, I think, strong in your position to make sure you optimize your outcome. but don't be so strong that keep the process from moving forward.
Right. Put as much out there. I mean, there's strategically put your cards on the table, I guess would be my approach. Ultimately, while, the results of and the occurrences in mediation are not going to be, subject to litigation and they're going to be largely confidential. It's still something where the other side knows, right? When you move to 200,000, you're gonna have a really hard time later going up by 50% if it is resolving a mediation. So, I mean, while there's nothing that's going to be binding about what's discussed or necessarily producible if this case is tried, it's still, practically speaking, something that a lot of our clients are concerned with, and I'm equally concerned with. That you want to put your cards on the table, but you don't want to just give it all, right? You need to be strategic. But I agree. In many situations, I will encourage all parties to share those mediation submissions, because then at least we go into it. And frankly, it saves a lot of time, right? Because both sides know what they're arguing about. Sometimes in early mediations, you don't even know what the other side's defenses are, right? So we're going into there arguing one thing, the other side's arguing the other thing. And little did we know, we have a very limited dispute. Maybe they're admitting liability. But we're spending all of our time arguing liability, and we assume that's what they want. So when we share that information up front, at least we can create a common basis, those commonalities needed to maximize the likelihood of a mediated resolution.
That's right. And you don't need to put all your warts or even any of your warts necessarily in your public mediation statement. You can share them privately with the mediator. But I think there can be some benefit to acknowledging where you're weak as well.
Now, any other guidance or advice for what attorneys and adjusters can do to maximize the likelihood of resolution at mediation?
That is another great question, Ashton. Obviously preparation is key and perhaps goes without saying, but I think always worth saying. Preparation is probably the most important factor in getting the optimal outcome. And you need to sort of start that preparation and figuring out where you're going to go from day one, right? Be flexible. Not all adjusters are called adjusters anymore. But somebody once said, look, they're adjusters. They're supposed to adjust. Don't be so inflexible that you negotiate yourself out of a settlement by standing too firm. And try not to play the mediator too hard with your position. If, again, as I said, you can certainly negotiate aggressively, but don't be, I guess, so convincing in where you're not willing to go or willing to go that perhaps you persuade the mediator that a settlement, really isn't going to be feasible. So, I think a good mediator hopefully works through that and is patient and encourages the parties to keep moving. But we're all human, and if somebody says we're never going to pay X, you may be inclined to believe that that's the case. And I'd say just look at the big picture. We tend to get tunnel vision in looking at our cases, and hopefully a mediator can help you look at the bigger picture. But if you're prepared to see that and have done that to some extent yourself coming in, I think that's going to be helpful.
Yeah, and rely on the fact that the mediators have seen a lot of these things before. They've handled a ton of these, and they have a relative level of expertise in figuring out where cases are going to go, what they should resolve for. Now, I have a mediation about a month ago. This guy's quite good. He's in the Midwest, and he has a practice of reviewing everything and then legitimately going to the party saying, hey, this is where this case is going to go. It's going to be $750. That's going to be where you guys are going to end up agreeing, having no idea where everyone's going to agree. And usually it ends up getting right to that number, and both parties are agreeing. So, I mean, obviously he's working towards that. He's setting the stage. And there's certain ways, it's a unique strategy, but it is kind of funny that that guy, he can look at this and realize without knowing anything, talking to him, he's like, yeah, I know insurance carriers. I know the sub-row side, the liability side. I know they're going to go to $750. They're also going to go there. That's where we're going to get it done, right? 8 hours later, Guess where we end up? $750. So, I mean, it's really kind of, it's fascinating. I always say just, rely on the expertise, give the mediator the reins, right? We don't need to say everything to the mediator. I don't need to give you my bottom line at the beginning. And frankly, sometimes I will. If I have a garbage case and we're really just trying to get something done, which sometimes does happen, we will sometimes just fully disclose everything to the mediator, put on the table saying, hey, help us get a deal. We need to get this done, right? But typically it's about feeding the right information at the right time, being frank, being forthright, and just playing ball and adjusting, right? That's important.
Exactly. Right. Exactly.
Yeah. In every case doesn't resolve at mediation, Jason, as I'm sure you know. I think you mentioned an 80% statistic. But some mediators I've worked with will request to stay involved after the fact. Do you ever make those requests or get those requests? And if so, what are the benefits of doing so?
Yeah, I think, any good mediator will follow up if a case doesn't resolve. I think, as I said, 80% roughly of cases resolve as a result of the mediation. That doesn't mean 80% resolve day of the particular hearing. So if a mediator isn't following up, I would encourage any parties to sort of reach out and perhaps prod the mediator. But hopefully they're doing that, on their own volition until, one or both sides fires them and says, stop, which usually doesn't happen.
And that's a question, Jason, that I actually ask most mediators I work with. What happens if we're relatively close? We both have expressed an interest in coming to an agreement, but our numbers just aren't totally in line and we just don't have time, right? It's just this, if this went for another 6 hours, maybe we could do it. What do you do in that situation? So most mediators say kind of what you say. Yeah, I stay involved. I'm happy to stay involved, assuming there could be a resolution on the table. And I always like to encourage my mediators to do so with obviously the consented defense counsel, because some of the older school mediators, you'll go there, they'll give you your 6 hours. When you're done, they're just out of it, right? They're done. You get your invoice, you're through. And I just don't think that does the right service to the case.
No, I think that's absolutely correct. In fact, I think the biggest complaint that I hear about the, much liked, revered, popular mediators is that they become so popular that they no longer have the capacity to follow up. So that shows you how important it is.
Yeah, I mean, it's like you reach out to maybe it's Joe Johnson or whomever that person is, that's the local mediator of choice for the last 20 years. Well, the hard part is it's like, wait, well, when's Joe available? You could come meet with him at 5:30 p.m. until 6 p.m. on Christmas. So, well, obviously, that's probably not going to work. And that's the same thing. If somebody is, booking out like that, then they're probably not going to have the ability to follow up. So I agree. And also give new people a chance. You never know who's going to be that right mediator. So now handling mediations, it puts us in a position where we get to see so many different negotiation styles, right? Every attorney is different. Every mediator is different. Every adjuster is different. I'd be curious what you've seen and and let's go into the bad traits. What are the worst traits that you've seen attorneys having when they go into mediation?
Well, one, I think lack of preparation, but presuming they're prepared, it would be just sort of standing by their position, making the arguments that they would make, at trial to a jury. I appreciate all of those and that information is important, but simply standing behind those, not looking at the other side, I think it makes it extremely difficult to work with a party who sort of doesn't acknowledge anything from a different perspective.
And that's one of the difficult roles that us attorneys have is that, when you are consulting with, when you're representing a client, it's important that you have to set appropriate expectations and give all of the information and give your opinions. I am the counselor. I am of counsel for my client, and my job is to counsel them. It's to provide advice, guidance. It's not just to be a yes man. And sometimes that can be hard for specifically a lot of defense attorneys I see out there where it's, we have huge exposure, but the client disagrees. So I'm just gonna agree with them, when what they need to be doing is inform their client of, hold up, like there is exposure here. You should resolve this in mediation, because otherwise you're going to pay, legal fees of another 20 grand to get this to trial, or 100 grand, whatever it could be. And I think that, being appropriate, attorneys need to explain the case to their client, make clear what their perspectives are, where they see this case going, and make those recommendations. Because that's the one thing I see. Sometimes I'll go to these mediations and the media will be like, yeah, the defendant has ridiculous perspectives on this case. I've tried to explain it. They disagree with me. Their counsel is not informing them, a fair value or what's going on here. And it's just, it's not going anywhere. So I fully agree. I think that by making sure that everyone's reasonable, I think that we can, probably get these things to resolutions. But that would be my number one, thing to blast the other side on, would be entering the mediation. Obviously, unprepared is the worst thing that you can get, because you're not getting anywhere if they have to learn the case while it's being mediated. But also just making sure that they've actually informed their client as to appropriate exposure levels.
If you don't take your gladiator hat off and put more of a negotiator, listening, open-minded individual hat on, you're not using the mediation process to its full potential.
Absolutely. Well, Jason, it's been an absolute pleasure having you today. I know there's a lot more we can talk about, but thank you for joining us. This has been fantastic. Again, excellent opportunity to speak with you today.
Ashton, thank you so much. Yes, there is plenty more that we could discuss, and I would be happy to come back for another episode to continue to talk about negotiating and mediating with you anytime.
Beautiful. Well, again, thank you. Thank you to everyone in the audience. This is Ashton Kirsch with the Subrogation Support Network, signing off from the podcast. Thank you.